Well, good afternoon, SLAE family. We have a fabulous guest today. I am really thrilled that she's taking the time out of her crazy schedule to come in here and educate and empower all of us today. My special guest today is Elizabeth Green. She is a lawyer and a partner at Pess & Katz Law, and she's going to give us a fantastic education. But before we do anything else, first things first, I would love to go ahead and welcome her. And then Elizabeth, before we talk shop and all your knowledge and pick your brain, always we want to learn a little bit about you as a person. So maybe you could share a little bit about your personal life outside of law, and then we'll dive in deep with the rest of it.
Thank you so much, Leanne, for having me. I really appreciate it. Love the videos that I've seen in the past. So thank you, and honored to be included among them. So I am, first and foremost, I am a mom, a wife, a sister, a daughter. I have 4 children. They are, the oldest is 23. What are they? They're 17, 19, 21, and 23. I had the pleasure of seeing my 21-year-old married this summer.
Congratulations.
Thank you. So she's married, she's in law school. So after years and years of talking about what a horrible mother I am for being a lawyer and working, she has decided to go to law school, and she suddenly has discovered that, oh, wow, my mother really did make time for me in her life. And she took some estates class, or learned a little bit about trust and estates, and said, oh, what you do, like, it's hard. So I'm beginning to get to see what happens when your kids mature a little bit. You know, my crazy busy schedule, I also do a lot of volunteering, serve on a board for my daughter's school, general counsel now, and a lot with education, a lot with planned giving, and just try to make each day something that's valuable for me. And so thank you.
That's fantastic. Now, let's take a second, since you touched on that subject. There are so many people who watch this that, you know, professional women that struggle with the balance of being a mom, trying to work, trying to do everything all at once. You know, your particular area, you work with wills, estates, all that good stuff, which we're going to talk about. How do you balance that, and what do you find most fulfilling about it?
So my answer is sometimes better than others is how I balance it. And I made the decision that you can have it all, but you just have to redefine what it means to have it all. And so I've always made it clear that my family is my highest priority, that when I'm at work, you have 100% of me, ish, but that, you know, that my family is super, super important to me. And so going to, you know, when the kids were little and I worked downtown, the science center was downtown. So I tried to chaperone the science center and the aquarium trips, as opposed to the ones that took us way out. So that's kind of how I did it for myself. And what I love about what I do is that I get to get involved with families. And I really, I am hopelessly connected to every single one of my clients, even the ones that I really don't like. No, sorry. No,
it's all good here. You can be honest here.
but really, I become part. I take when I'm dealing with estate litigation, I am personally offended when it offends my client. When I'm doing business work, you know, it's my company that we're selling or that we're engaging in a transaction with. And when I was starting out, I would, you know, I sort of become whatever the client needs me to be. And once upon a time, I got to be the kid in the estate planning, and now I'm like the grandparent. But you know, really, I love that I spend time getting to be involved with families, and the people also do a lot of estate administration when I'm able to help somebody to navigate through something that's painful. I'm sorry for their pain, but it really is so fulfilling to me if I'm able to help ease that pain a little bit and make the transition. So that's what I love. I'm this unlicensed social worker, and I have clients who tell me, you know, it's okay, I know you're charging me for this, but I'd have to pay a therapist anyway. So so it's good.
Yeah, this is great, because One of the things that is interesting in our SLAE community here is that we have lots of people in different places in life. We have people of all different ages. We have people in different financial situations. And, I would love to take a few minutes and talk about that. If you're young or if you're in your senior years, if you have, barely enough money to cover your bills, or if you're wealthy, it seems that the common denominator is that everybody needs some elements of either wills or power of attorney or medical directive. Can you talk about why that is important no matter where you are in life? I know that's a really big question, but if you wouldn't mind.
No, absolutely. So I went to law school just after the Terry Schiavo case. And so, that loomed large, this idea of a young woman who needed end of life planning, and was so young that she hadn't thought to do it. And that sort of colored my knowledge of the fact that there is no such thing as being too young to think about it. Now, shoemaker's kids, only one of my over 18s has a power of attorney yet. But I did do it for the oldest right away. So really there is no such thing as too early, and there is no such thing as not enough money. So talking about the couple of documents, to me, the most important document for anyone to have is a power of attorney. I know that we have listeners from all across, at least across the United States. I'm not sure how far you reach. So in different states, there may be different statutes, but in Maryland, if you don't have a power of attorney and you are no longer able to handle your own legal or financial affairs, so you're in a coma, whatever it may be, dementia, whatever it may be, but it happens to a young person can have an aneurysm, you're alive, but you're not able to do those things. If you don't have a power of attorney, if you haven't appointed someone, the only way that your legal and financial affairs can be taken care of is to go for a guardianship, which is a court process. And it takes a while and it costs money, definitely much more money than it costs to just simply get a power of attorney in place. So everyone 18 and up needs a power of attorney.
Medical someone could be in a car accident, or certainly we've seen a lot of illness with the pandemic. Things can happen.
Right. And also, so, I have kids who've gone away to school, and sometimes things need to be signed, and it's much easier if they can say, oh yeah, it's fine for you to sign for that for me because they have a power of attorney and I can do it. I have my parents are older, and my father has advanced Parkinson's. And by the way, their argument is, we paid for your college so you can use in law school so you can use us as examples to further your career. So I'm allowed to talk about them. But what I'm able to do, since I share power of attorney over my father with my mother, is I can't help with the other caregiving that she does.
Yes.
But if I can help take care of a banking or a tax matter for her that she doesn't have to, it's a big deal and it helps her a lot. Now, it's important to remember that it is a big thing that you're giving to your child. And so you have to be able to trust your child to act in your best interest. It is a fiduciary role, but it's really helpful. And so it's a good document to have. Medical directives also. So in Maryland, we have a statute. If you don't have a medical directive, there is a method of designating who can speak on your behalf. But
if you don't mind, Elizabeth, because I don't want to assume everybody's familiar with medical directives, could you just take a second and explain, where that comes into play and what that does, please?
Sure, absolutely. So there are a couple of different pieces. Once HIPAA came around, nobody can talk with your doctor other than you. Mm-hmm. So if you want, using the example of the 18-year-old child, technically, I can't even really make a doctor's appointment for my children if I don't have the right. So sometimes doctors will say, do you want to designate someone who can speak with us?
Yes.
But often not. And so there's the designation of the healthcare agent, the person who can talk with your doctors. And then there's the medical decision making. And there are a variety of different documents. People are familiar usually with the concept of a DNR. That's the end of life, do not resuscitate. but there's a whole lot between having a medical directive and a DNR. So as people's parents age and they want to be able to maybe make decisions with regard, and along with their parents perhaps, for are they going to have a biopsy? Are they going to have a surgery that has could have a very positive outcome? If you don't have someone appointed and you can't speak for yourself, then the doctors are in a difficult place.
Sure.
And it can delay, even though there are statutes that will put somebody in that position, it can delay your treatment. And nobody ever wants to have a situation where something could happen easily, but it can't because you don't have the document in place.
Sure.
So again, 18 and up, you really should designate who it is that you want to speak for you with your doctors. Doesn't mean that you have to give them that right immediately, but even if it's only upon incapacity or inability to speak. And the other piece is, for those of us who are blessed to have more than one person that we might want to speak for us, we can designate an order in which they can speak. We have very good friends who have an extremely large family, and she was in the hospital, and it was clear that while she loves all of her children and all of her children love her, they weren't all going to follow her wishes with regard to her care. And so we revised her documents to make sure that the people who could speak for her were the people that she wanted to speak for her.
Sure.
Out of her multiple children. And then wills. So there are lots and lots of ways that we can leave our assets to other people. So if someone has just a house, essentially, they don't really have much else in terms of assets, maybe a small bank account. There are ways that we can leave a house or leave a bank account or leave a life insurance policy to someone. It's still a good idea to have a will, because the will allows us, there are really 3 things that happen in a will.
Okay.
1, if you have kids, you establish guardianship. And sometimes people will say, well, everybody knows who would be the one who would step in. And I was privy to a case where a couple who was in their 40s was in a car accident. Everyone in the family except their 7-year-old daughter died.
Oh.
And they had no wills. Both sets of grandparents loved this 7-year-old, and she was all that they had left. And there was a horrible custody battle over her, not because no one wanted her. Two families wanted her, but if the parents had a will with guardianship in there, they could have said, this is what we want to have happen. Maybe it was an aunt and uncle, maybe it was a best friend that they would have wanted. So you establish
a big thing, like who has your child if something happens to you. That's more important than any amount of money or anything else that could be on the table.
Right. And assuming that my brother is not listening, and if his wife is, that's kind of get bad. But I love my brother, and his kids are amazing people, but they're very different from the way that we raised our children. And so, if he had been the one raising my kids, they would have been awesome, but they wouldn't have had my stamp and the way that I want them raised. So, right, you have an opportunity to establish guardianship in your will. You also pick who it is who's going to make the decisions, who's going to identify assets, distribute the assets, take care of all of that for you. And not everybody's capable of doing that. Some people, that's going to be just too much of a burden for them. So you want to establish who it is who's going to be capable of doing it. And it's not always a family member. Sometimes it's a good friend. Sometimes it's a trusted advisor. It could be lots of different people. And then the thing that we think about our will doing is it also determines who's going to get what you have and how. And you can use beneficiary designations, and they can be very effective. But an example of where a beneficiary designation may not help is usually people will say, okay, we have 3 kids. We will leave our, my life insurance policy is going to get divided among my 3 kids if my husband predeceases me.
Mhm.
But if you don't write it the right way and you have grandkids and one of your children predeceases you, lots of ifs, sorry, then the grandkids may be cut out. And that wasn't really the intent. Whereas
So
with
we're
a
trying to
will,
cut out a family, but they didn't factor that in.
exactly. So it sometimes is really with, wills are definitely more words, but it gives us an ability to craft a result that may be helpful. And at some point, Leanne, you and I were talking a little bit about trusts. So
Yes, so
sometimes
hold on, I want to ask you one thing before you do trust, if
Yeah.
that's okay. So if that's the case, then should people update their will every fill in the blank amount of years? I mean, I would assume people shouldn't have a will, and then if they've got a growing family, they may want to change that, or if their marital status changes, they should be doing that as well.
So we say every 3 to 5 years, you should at least look to see if it still fits. My goal is that a will at least be good for 10 years.
Mhm.
And hopefully will be good enough if you never update it. But and then the other thing is when there are life cycle events. If there is a marriage, a divorce, more children, a lot of people like to update their wills when they have grandchildren. Unfortunately, I'm at the stage of life where I have more and more friends that are getting divorced, and the conversation generally goes, so and so and I are separated, and I say, have you checked your beneficiary designations? Have you changed your beneficiary on your IRA? Have you, what are you doing with your 401k? And I make their head spin. But because even if you think you're all taken care of because you have a separation agreement, if you don't change the beneficiary of your 401k, guess who gets it? Does not matter that your spouse gave up that right in the separation agreement. Generally speaking, they've waived their right to receive it, but they haven't waived their ability to receive it.
Wow. So you could end up giving everything to the person that you're trying to separate and divorce.
Yep.
Oof.
Yes.
That's probably an eye opener for a lot of people watching this.
and if you're separated and not divorced, you really should make those changes. If it's a contentious, long, or not contentious, you just decide neither one of you is really motivated to get the divorce, to finalize the divorce.
Yeah.
Make those changes, because even if there are certain things that by operation of law your spouse will get, like a percentage of your estate, if somebody dies while separated but not divorced, the spouse under most state laws has a right to some portion of the assets, but by changing the beneficiary designations, you may be able to limit how much the spouse can get.
Gotcha.
So life cycle events every 3 to 5 years, and certainly if there's dust on it, it's probably too old.
Thank you for letting me take you on that tangent. And then we were going to talk about trusts. And there's a lot of misinformation around trusts if people aren't really educated by, someone like yourself. So some people think trusts are for rich people. People think trusts are for kids. Like, can you take a minute and give your crash course on trusts and when they matter?
Absolutely. So there are generally two different kinds of trusts. There are revocable trusts, sometimes called living trusts, and then there are irrevocable trusts. So an irrevocable trust, by definition, cannot be changed. But of course, being lawyers, we always make a way that we could change it. But one of the ways that some of the wealthier among the listeners might use an irrevocable trust is to remove assets from your taxable estate. So if you have an estate that would be subject to estate tax, or that would pay estate tax, you might take assets and put them into an irrevocable trust to get them out of your estate. Irrevocable trusts are often also used for young children. If somebody wants to give money to their grandchildren, although some of that has become less with the advent of educational IRAs, which I would definitely encourage rather than setting up a trust for your grandkids. An irrevocable trust can be used for special needs and for medical assistance planning. So there are times that we do it. But that's sort of where the irrevocable trusts come in. But more common, people have these living trusts or revocable trusts. What a living trust does is you don't remove it from your taxable estate. It's still, you still file the same tax return every year, but you take your assets and you put it into this trust, and it means that they don't go through probate. So what does that mean and why? Why do I care? So probate is the court supervised transfer of assets. So when they talk about, taking your will to the courthouse and having the will read, et cetera. So probate is the things that pass under your will, those that do not have beneficiary designations, those assets it's a public process. It is a court supervised process. There are levels of permission that we need to get from the court. In some states, like in Maryland, probate is not a particularly expensive process. It's not a particularly long or onerous process. In other states, California, Delaware, Florida, avoiding probate is a good idea. So if you're in one of those states, or and I'm happy to take after the thing questions if is my state a bad state, but it may be a good idea to save money to set up one of these trusts. You transfer title to your assets into your trust. You are still in charge of them. You can take your assets in and out. You can pay your mortgage. You can pay your grocery bill out of your trust, whatever you want to do. But it avoids going through probate. So do you have to be wealthy? No.
Okay, so you can, just to be clarified, you can access the money in there. You're just putting it in a protected place, essentially. Is that safe to say?
Correct. And that can be helpful in a couple of different ways. I've talked about the probate piece. It also can allow a child to step in and help take care of a parent, or another family member come in and help take care of you. Your assets are already gathered together. I often will find kids whose parents had assets in 1,000 different places. We'll say, okay, now I want to trust because I don't want my kid to have to find all these assets and change their title. So I'm going to gather it all up now, and then it'll be easier for my child when I die. The other thing about revocable trusts is that it keeps the assets private. When we have a probate, when we take our estate through our will, through probate, everything is filed and is available publicly. And I actually got a phone call one time. There was an extremely wealthy Baltimorean who passed away. I didn't have anything to do with the estate, but I got a call from someone from our local legal paper, the Daily Record. And he said, well, we see that he has a small estate and it reports $50,000 worth of, whatever. Why do you think he had that? And I responded quickly, because he wanted to keep people like you from knowing what his assets were. So, and then we talked about, what it means. And, for most people, the things that they forget to transfer are not, hundreds of thousands. It's a couple dollars. But this guy was worth, tens of millions. And so there was a fairly large amount that didn't go through there. But I also had a client one time, a lovely woman. She was a second wife, and her husband's, they didn't have children together. And her husband's cousins had always expected that they were going to get his money. And so they were very, very upset at the thought that he might leave his money to her. And we decided to create a revocable trust because, they had been married for 30 years, which I don't know. I kind of think that's a real marriage.
I think that's definitely a real marriage.
And
even if it's not a first, not many make it that long. That's a really long time. Yes.
Right. Exactly. And so we created a revocable trust, which meant that these nosy cousins didn't know exactly how much money she got and what she was able to do with it. So it was really useful to sort of protect that. And the other thing you can do with a trust is if he had wanted to make sure that his wife could use all of the money she needed during her lifetime,
Yes.
but he did want to make sure that it went to his cousins eventually,
Mhm.
he could have provided that in his trust. He could have said, I want you to have the use of the money
Yeah.
and any needs, but when all is said and done, here's what's going to happen to it. It's not going to your cousins, it's going to my cousins. So that can be good. And for any of you, if there are any of you who are living in your boyfriend's home, or your boyfriend is living in your home, a trust can be really useful so that you can set the parameters. For 18 months after I die, he can stay in my house as long as he pays
nice.
the
Yeah.
regular bills. And then it needs to be sold or something like that, because, who wants to have someone they love kicked out,
Yeah.
30 days
In
after
their
they die.
mourning anyway, if something happened to the person.
Right. So it allows for some creativity.
Okay, and then you were going to say one thing and I jumped in with a question, so I apologize for that. But you were going to talk about money. Do people need to have a lot of money to have a trust? That's what you were about to go into when we took that side tangent.
Yeah. So no, really don't. You don't. Especially in terms of the revocable trust, if you live in a state where probate is expensive, it's probably worth your while to create a trust so that you can avoid those expenses. And if your spouse is likely to need the money quickly, or your kids are likely to need the money quickly, it allows access more quickly. If you have a person, if I have sometimes I'll get a phone call from someone and they have a house, they're multi-generation living in the house, maybe, a bank account that never really has more than $20,000 and, and a $5,000 life insurance policy. It's not going to pay for them to have me do their planning. But what they might do is use a special kind of a deed called a life estate deed that provides what's going to happen to their house. You want to make sure that the person living in it is able to stay living in it, or whatever it may be. Put a beneficiary on the bank account and on the life insurance policy. So there are definitely times when there are people who might not have a will. But to do a very simple will doesn't have to be expensive. Even there, sometimes people will call me and I know that they don't need any tax planning. I have people that I refer someone to when they just need something, they need the $500 will. There are people that do it and they do an okay job that will be good enough for someone who doesn't really have a lot, but maybe needs that, that guardianship provision, or needs to have, somebody who's going to be appointed, who's going to, they don't have any family members. So we need to make sure that there's someone who's going to step in and to identify to take care of the things. So
great information. I really appreciate you taking the time and all your expertise in this, because I know you live and breathe this all day and all night, except when you're with your kids. Now, if somebody is, we have people who watch us live on Facebook, watch on Facebook for the next 2 days or so, and then we have a group that'll watch it on YouTube as well. If somebody has any questions, or they're looking for a brilliant lawyer in Maryland, is it okay if they reach out to you? I know you've joined the Facebook group.
I did. And absolutely. I'm always happy to talk to people. And if you don't live here, certainly if you live here, I'd love to meet you. I'd love, I can imagine that just from the little bit that I've seen, you have just this amazing group of women and a couple of men who listen, who are, who would be great to work with. But if you don't live here and you're looking for someone to work with, I'm happy to talk to you. I think the other thing is to sort of know where to go, where to look. And I would suggest that you consider, if you have an accountant, ask your accountant who he or she recommends, a financial advisor, insurance salesman who you work with, or broker. Ask them. And then probably my favorite referral source is my clients. So
that makes a ton of sense.
Yeah. So if you are thinking that you really need to take care of this, and you have a friend who you think is smart and probably, has taken care of it already, ask them if they like their lawyer, because that may be a really good way to figure out who can help you with your estate planning. But
That's great.
yeah, I mean, but it's really important to think about it. And I guess the other thing that I would say is, if you don't know who you want your assets to go to, and you don't know who should be your power of attorney, and you don't know who, maybe you know who your assets should go to, but you have no idea who would be a good guardian.
Hmm.
Don't avoid your planning. Go to someone who does this regularly, because we've got lots of ideas. And so we can sometimes tease out of someone ideas of who would be good to step in. And it's not it's not a decision you make that you can't change. So
Yes.
putting in not the best person is better than not putting in anyone.
Well, you know
So
what, if you don't have somebody that you find compelling that you would want to have take care of you, that means that the odds are you could end up with someone you really don't want to have take care of you.
right, exactly.
I would think it'd be a little easier if there's someone you're like, oh, if anything happens to me, this is what I want. It would be more difficult in the other circumstances. So having a conversation like that is really great advice. I'm really grateful that you're here, and congratulations on all your success, and your career is fantastic. Your kids are great. And now the apple hasn't fallen far from the tree. And now you've got a daughter who's doing exactly what you're doing. It is amazing. So everyone, that is Elizabeth Green, our brilliant lawyer today. We thank her so much. And, feel free to share this with other people and invite them to come watch so they can learn as well. And then finally, I do have one more announcement. If you do not know, we do have a YouTube channel now, and finally have an Instagram account too. So you can look all those up for SLAE with Leanne and Gabriel if you want to be able to see who's coming up or see past interviews. And I'm very excited to announce that in our Facebook group, we have now crested 1,000 people here. So stay tuned next Tuesday, because something special is going to happen. And I'm not going to tell you what it is. But if you did enjoy today, please leave a comment, question. It's really helpful feedback. If there's anything you want to share or ask, and if you're watching this on YouTube, the same thing. So again, thank you so much, Elizabeth. You're the best.
Thank you, Leanne.
And we will see you all next Tuesday for our 1,000 surprise. Have a great week. Take care.
Thank you. Bye.